So we'll see this topic, okay, relation between fundamental rights and DPSP. So fundamental rights given under part 3, DPSP provided under part 4. When we talk about its relation, there also exists a lot of differences between them. Like fundamental rights, we can go to the court, it's enforceable. DPSP is not enforceable. Fundamental rights are like positive obligation on the state, negative obligation on the state. DPSPs are like positive obligation. State should do certain thing. It's an obligation on the state. But fundamental duties, mostly it says that state should not do this certain thing so that we are able to enjoy our fundamental rights. Okay, so even though there are a lot of differences or distinctions between fundamental rights and DPSPs, the framers of constitution always mentioned regarding the relation also that exists between them. So there also exists relation between fundamental rights and DPSPs. When we talk about the framers of constitution, even they highlighted that relationship. So Dr. B.N. Rao, he anticipated that this conflict, that there is going to be conflict between fundamental rights and DPSPs in the coming days. And how do we address it? In case there is a provision which is there in fundamental rights and something is there in DPSP and something is conflicting, how do we resolve it? So he anticipated that there can be conflict in the future on these two provisions. And how can we do it? We can resolve it by way of harmonious construction, and compromise on the part of judiciary would in future resolve this conflict. When we say harmonious construction, right, there are different ways or methods of understanding or interpreting a certain provision. Okay, like we know that the provisions in the statute, right? When you look at any certain legislation, do you feel that the provisions are complicated or you are able to understand it? Maybe Indian Contract Act, if you open, do you think the provisions are easy to understand or a bit complicated, the writing skill? Yes, little bit it is complicated. Sometimes we might not be very sure on what a certain provision means, what a certain word means, right? So because it is complicated, sometimes one provision might have 2-3 different meanings also. It can be interpreted in different ways as well. That's the reason why we have different rules also. Okay, there is one subject which you will get, it is called as interpretation of statute. It helps you understand how different provisions are interpreted by judges, how they derive meaning out of these provisions. Okay, so out of those different rules, there is one called as harmonious construction. Harmonious construction mainly says that sometimes it might happen that there is one legislation. Okay, within one legislation, there will be multiple sections, multiple provisions, right? It might happen that two provisions are conflicting with each other. In one legislation itself, one section says something, another section says something else. It's conflicting with one another. In such cases, because it's there in one single legislation itself, we cannot say that this is going to apply or this is not going to apply, but rather we should try to balance both of these, how both of these can exist at the same point in time. Like that, judges try to derive a meaning. That's called as harmonious construction. That if two provisions are conflicting within one legislation, try to understand the provision in such a way that both the provisions can remain at the same time. We don't need to accept one and reject one completely. Both provisions can they harmoniously exist together or not, right? So B.N. Rao said that by way of harmonious construction, we can remove or reduce these sort of conflicts that might arise in fundamental rights and DPSPs in the future. Then Dr. B.R. Ambedkar was also of the same view like Dr. Rao, and he suggested and said that it is intention of Constituent Assembly that in future these principles enacted in this part be made the basis of legislation and executive action that may be taken hereafter in matter of governance of the country. Like what we have seen while studying DPSP also. A lot of legislations were introduced based on these principles. A lot of schemes a lot of benefits are also being provided to people based on these directives, right? So he said that this is how we need to make this applicable, that legislature will try to make legislations and executive will try to introduce different schemes, different privileges, different benefits, and that's how we can make these DPSPs a reality. So these are nothing but fundamental in governance of the country. These are very important. Both legislature and executive need to keep these in mind while performing their actions. Okay, then Justice P.N. Bhagwati defined the relation between fundamental rights DPSP as it is not possible to fit fundamental rights and DPSPs in two different strictly defined categories. He said that both of these are so much related, so much interconnected with each other that we cannot actually like strictly separate these as two different things. They both are interrelated with each other. So it can be presumed that the observations given by constituent framers and justices that fundamental rights and DPSPs are interrelated to each other. Okay, so there are various judicial interpretations as well, wherein court has also mentioned about it. Okay, there was one case, State of Bihar versus Kameshwar Singh, wherein Supreme Court relied on Article 39B and held that certain Jamindari abolition laws had been passed for a public purpose within the meaning of Article 13, Clause 2. Directive principles were not merely the policy of any particular party, but were intended to be principles fixed by the Constitution for directing the state policy. When we talk about property rights, right? So there are certain Jamindari abolition laws which were introduced, right? So these laws were introduced for public purpose. It's not introduced for benefit of the government or benefit of the ruling party, but rather for public purposes these are being introduced. And why these public purposes are being taken? Because under directive principles, the government is having, the state is having a responsibility to provide these basic needs to the people, right? And in order to provide it, they would need to acquire plots of land, and then they need to start with developmental work, start with infrastructural work. So these two things are very much related with one another. Muhammad Hanif Qureshi case, do you remember, regarding cow slaughtering? Religious right?
Yes.
Yes, ma'am.
Yeah, what was it all about?
Yeah, he approached court under article, I don't remember the article name, right to religion or practice, religious practice, whereas government banned cow slaughtering. He was pleading for justice, as in it is against the religious activity.
Yes, Article 25 he approached. Right, so Muhammad Hanif Qureshi, wherein petitioner said that these laws are violative of his Article 19(1)(g), because he was into that profession of slaughtering of cows, so it violated his right to enter into any profession or business, and also it violated his religious rights, Article 25. But Supreme Court relied on Article 48, and Supreme Court said that even though you have right to religion, even though you have right to practice any profession, there is also Article 48 in the Constitution, which puts a restriction on the state to ensure that they can pass these anti-slaughtering laws as well. So these two things are related. We cannot just ignore one and rely on one. Okay, so what court said is that your fundamental right to practice religion is not being affected, because slaughtering of cows is not like an essential religious practice that if you are not allowed to do means you cannot practice your religion. It's not like that essential. And also when we talk about freedom to practice any profession, it's not an absolute right anyways. There can be restrictions imposed. Right, so the state should take note of directive principles in determining scope of fundamental rights. To what extent can you enjoy your fundamental rights? It's not an absolute right. If directive principles is imposing a restriction on the state that you need to protect the animals and stuff, then in such cases, we need to understand both of these like together. Fundamental rights alone, DPSPs alone, we cannot study it like that. So that's nothing but like harmonious construction. Both the things taken together, how can we proceed with it? That you have right to practice religion, you have right to enter into any trade, practice, vocation, but subjected to some limitations. Then when we talk about principle of harmonious construction, it was also applied in other cases also. So there was this Kerala Education Bill 1957, wherein Supreme Court, while affirming primacy of fundamental rights over DPSPs, it held that court may not entirely ignore these DPSPs laid down in Part 4 of Constitution, but they should adopt the principle of harmonious construction. Not like you ignore one thing completely just because it's non-justiciable or something, but we need to apply it harmoniously. So harmonious construction we need to apply, and should give effect to both as much as possible. To whatever extent possible, try to apply harmonious construction rule over there. Supreme Court asserted that there is no conflict on the whole between fundamental rights and DPSPs, but they need to be studied together. Harmonious construction can be defined as provision of fundamental rights and DPSPs should be read harmoniously hand in hand. And in case any conflict arises, then court can refer to any particular law or interpret any law so as to give effect to both as far as possible. To whatever extent possible, try to balance both the things together, because they are not like one is important and another one we can completely ignore or something. Both are very much related to one another. So there was this case Golaknath versus State of Punjab related to again Jamindari abolition only, related to land property rights, wherein Apex Court called this interrelation an integrated scheme which is elastic enough to change with the passage of time or with the change in society. This view of Supreme Court created uh, great sedition in the country. So when we talk about these, the relation that exists between fundamental rights and directive principles, it's not like very rigid or something. They are also bound to change with changes in time, changes in society. In Keswananda Bharati case, it was judges showed a great concern for DPSP. Justice Chandrachud said that DPSP should not be permitted to become a mere rope of sand. It's not like they exist, they are there like a constitutional provision, and in reality, these do not exist, these are not given any importance. It should not happen like that. If the state fails to create conditions in which fundamental freedoms could be enjoyed by all, the freedoms of few will be at the mercy of many, and then all freedoms will vanish. When we talk about the fundamental rights also, whatever rights are guaranteed to citizens, we need to ensure that everyone is able to enjoy those fundamental rights. Same ways under directive principles, if any policy or if any scheme is being introduced, there also we need to think about benefit or welfare of the majority, right? That all the people belonging to that same class or same section of the society are being benefited under the scheme.
Ma'am, could you please explain me the facts of that Keshavananda Bharati versus State of Kerala?
It was also related to this Jamindari abolition laws only. So there is like a series of cases: Golaknath, Sankari Prasad, Sajjan Singh, and then Keswananda Bharati. Okay, so initially these cases were filed, wherein there was like differences in opinion. Okay, that whether Jamindari abolition laws are valid or not, whether this, because it's added as a fundamental right, can this be taken away or not? And court was giving different viewpoints on whether it should be done or should not be done. So in Keshvananda Bharati, there was a math in Kerala. From that math also, big area, it was like a big area, huge area of land. From there also, like one major section was acquired by government. So all these Jamindari abolition laws were like if you are an individual or if you are some entity also, only this much property you can hold. Okay, if you have this much property, only this much you can hold. Like some limit was fixed under those legislations. Only this much you can hold. Whatever is remaining, that government is going to take it back. Okay, so government will take it. Maybe some portions it can give to the people who were maybe cultivating in your area or something like that. Like that, all the different states were passing legislation, and those were mainly challenged. And court was giving different viewpoints, constitutional, unconstitutional, different viewpoints were given. So finally, Keshwananda Bharati was the case which settled this matter once for all. And after that, it was held that this right to property is not a fundamental right. It was moved to a constitutional right under Article 300A. So in this case, the math, a lot of area from this math was taken by the government of Kerala under a Jamindari abolition law only, land reform law only. So he filed a case challenging that, and there a lot of different matters were taken into consideration: amendment power of the constitution, fundamental rights, basic structure doctrine was also given. So there only this relationship between fundamental rights and DPSP was also referred. Okay, so this case basically settled all these confusions that were there, whether preamble can be amended or not, whether fundamental article 3 this 368 is absolute or not, whether it's giving powers to parliament or not. A lot of questions were being answered in this particular case only. Even though it was just related to land reform laws, a lot of different matters also, this is like important. Okay, you will get this case properly in this amendment provisions of constitution as well. Okay, there, because this is the case which settled all those confusions that were there relating to article 368 also. Okay, so fundamental freedoms. So relation between fundamental rights and DPSP is cohesive in nature now and is an essential part of basic structure of Indian constitution. So this basic structure doctrine was also for the first time developed in this case only. And it was said that we are not as such defining that only this is basic structure, but we are keeping it open. In all the cases which are going to come in the future, courts can include new things in this list of basic structures as well. So both are complementary and supplementary to each other, and states should follow the guidelines which are mentioned in DPSPs, and that, in that way also it can help protect fundamental rights. Else they will have to face consequences in next election. So sometimes you would see under DPSPs government would try to introduce a lot of schemes thinking about elections only, right? Because in the next election they can say that okay, these are the schemes, these are the benefits that we have provided, and those benefits in a way or the other ensure that we are able to enjoy our fundamental rights only. Like you have seen this right to education directive principles talks about right to education, that to whatever extent possible provide it. And it is being provided also by the legislature. We have a legislation now, we have article 21A in the constitution being added. So all of that indicates that there is a strong relation between DPSPs and fundamental rights, and both the things should be taken together and should be studied together only. Okay, is it clear?
Yes, ma'am.
So harmonious construction is very much important when we want two different things to prevail at the same point in time. Okay, so that same principle should be applied for fundamental rights and DPSPs as well.